Kenyan subsidiaries of two United States of America registered exclusive private air charter service firms represented locally by flamboyant Nairobi businessman Chris Obure, who has a history of multiple run-ins with the criminal justice system, including gold scamming, and now a murder suspect in killing of Calvin Omwenga, have failed in a bid to lift an order imposed on its bank's accounts, which were frozen over suspicions that millions were wired from outside the country through an intricate money laundering syndicate. The presiding judge of the Anti-Corruption Division of the High Court, Esther Maina, dismissed application to unfreeze the bank accounts belonging to Kenyan Private Jet Corp and Glowjet International Limited. Justice Maina said it was ironical for the two firms, which are subsidiaries of global multi-billion-dollar companies with operations in 47 countries, with financial muscle to support the Kenyan entities, to claim that it was unable to meet its financial obligations because of the freeze. The judge said the facts presented to the court by the Assets Recovery Agency (ARA) disclosed reasonable grounds to believe that the funds in question are proceeds of crime. Justice Maina ruled, quote-unquote, that prima facie evidence is of course subject to the agency proving its case on a balance of probabilities at the hearing of the forfeiture application, if any, where the respondent shall also get opportunity to present its evidence. The High Court issued the freeze on September 22nd, 2023 on two bank accounts at I&M Bank in the names of Kenyan Jets Corp and two others in the names of Glowjet held at EcoBank, holding over 18.9 million shillings. The freeze order prohibited the operators or their agents or representatives from transacting, withdrawing, transferring, using and any other dealing with the money in the bank accounts. The bank accounts includes 54,257 US dollars, 696,070 shillings held in account number 0190-405-736-6250, registered in the name of Kenyan Private Jets Corp Limited held at I&M Bank, and 24,712 US dollars held in account number 6658-001-882 in the name of Glowjet International Limited, and 1,134,691 shillings held in account number 665-8001-881 in the name of Glowjet International Limited, held as EcoBank Limited. Obure is the local representative of the two companies. Kenyan Jets Corp is an exclusive executive international private jet chartered services, a subsidiary of a company registered in Miami, USA, while Glowjet is a subsidiary of Glowjet International Corp, a firm registered in Florida, USA. ARA applied for the freeze following inquiry into the activities of the firms, which established that there were reasonable grounds to believe that the accounts received huge deposits of cash suspected to be unlawfully acquired. Through counsel Mohammed Ado, the agency said the money in the bank accounts is reasonably believed to be proceeds of crime obtained through money laundering, and the firms have no right to remain with it. He contended that the argument that the money was unlawfully acquired can only be canvassed at the hearing of the forfeiture application, but not at this stage. According to ARA court documents, financial investigations conducted by the agency revealed complex fraud and money laundering schemes conducted by the Kenyan Private Jets Corp Limited and Glowjet International Limited, their directors and associates, rendering the above funds proceeds of crime liable for preservation and forfeiture. The said bank accounts received suspicious huge cash deposits from various suspicious sources, and investigations established that there are reasonable grounds to believe that the funds in issue are obtained through illegitimate means. ARA told the court, quote-unquote, the investigations have revealed that the cash deposits were unlawfully acquired, hence proceeds of crime pursuant to the provisions of Proceeds of Crime and Anti-Money Laundering Act, and investigations further established that the funds were obtained from various suspicious sources and spent or dispersed through suspicious activities and transactions in a classical money laundering schemes. The respondents are subsidiaries of highly revered conglomerates with international presence with annual turnover of millions of dollars. So should the court find that the funds are proceeds of crime, the applicant will still be able to recover the amounts. The Air Charter Service firms maintained that no cash deposits have ever been made in the subject accounts, as all funds therein are wired from Central Revenue Collection, Disbursement and Financial Management Center, based at the company's headquarters in Orlando, Florida. Louis Itebo Pamba and Geoffrey Somoni Birundi explained in affidavits filed in court that because of the preservation orders, the parent company was considering closing the Kenyan subsidiary and moving its operations to South Africa, citing a hostile environment for international strategic investment. While pleading with the court to lift the order, the firm said they were subsidiaries of revered conglomerates with annual turnovers of millions of dollars, and in the event that the court finds that the funds are proceeds of crime, the agency shall be able to recover the money. According to Pamba, the accounts receive money from their holding company in the USA to make payments for salaries, service providers, and bills. He said the preservation orders were obtained on the basis of allegations, suspicions, and presumptions contrary to the tenets of law and natural justice, as no evidence was stable to demonstrate existence of a prima facie case to justify the order. The court was informed that the agency summoned the firm's two top directors for questioning, while critical information and supporting documents relating to the operations of the companies were presented. The firm said checks issued to third parties have been dishonored, a move that was likely to attract penalties, and the firms ran the risk of being subjected to expensive court action and litigation for failure to discharge their financial obligations and commitments to third parties. Further, that the orders have negatively affected revenue flows due to customers' due diligence before bookings, leading to loss of revenue. The judge, however, said checks are generated internally, and the mere fact of their having been withdrawn is not evidence that they were not honored.